I'm here with attorney Sujata Gibson. We are in Brooklyn. We're outside the courthouse here where there was an appellate hearing in the Garvey case. You were co-counsel with Chad LaVeglia. He was arguing that case before the appellate justices today. I want to ask you to explain a little bit about the case, just some basics for people who haven't been following it, and then tell us about the appeals process here today.
So this is an appeal of a landmark win that our movement had in October of 2022, I believe. But the judge in the lower court ruled that the 16 sanitation workers who were fired for taking the vaccine mandate were fired under an unlawful policy. So not only did he order that they go back to work with back pay, but he also declared the entire city mandate null, void, and unenforceable as a violation of the separation of powers, and also because it's arbitrary and capricious, which means that there's no rational reason for it. The reason for that was especially because while they were saying that it was a public health initiative, the mayor then started to use his power to make carve-outs for wealthy and powerful industries like athletes and entertainers and their entourages, who were all exempted for economic and social reasons rather than actual health concerns. And so that triggers under the law a variety of violations, one of which is that it becomes lawmaking instead of a health regulation that's properly within the scope of the Department of Health's authority. And it also shows that the mandate is arbitrary and capricious. So the city appealed, and today we were arguing, Chad was arguing that appeal.
Can you talk about some of the key arguments that were made, by the city and your responses to those arguments? There was one of the things that people might not understand is the Boreali issue that was brought up a lot by both sides. Maybe can you explain what that is and what that's all about?
Sure. Well, there's in our Constitution, like in most state constitutions, there's a requirement that the legislature make the policy decisions and that agencies and the executive branch merely enforce and implement those decisions. And then, so that's a separation of powers doctrine, it's called. And the way that you look, it's not always so clear whether an agency like the Commissioner of Health or his agency is acting within delegated power or whether he's crossed over into policy making. But one way that the courts have determined to check is to go through these factors called the Boreali factors. And that arose from a case where the Department of Health had implemented an indoor smoking ban. But they had all these exceptions and carve-outs for certain industries that they thought would be economically harmed or that they cared more about than others. So certain kind of like convention centers and other places were exempted and others weren't, and it wasn't for a public health reason, it was for economic reasons and social reasons. So very similarly here, we have a vaccine mandate that is, that they've invoked the health implementation powers to enact for all city workers, and then they made carve-outs for industries that, like the athletes and entertainers, industries, where some of the mayor's top donors had serious financial considerations. So it's very similar to the Boreali case. And so what we were arguing was those economically driven decisions really make this law void because it violates our constitutional right to have elected lawmakers make the laws.
Mm-hmm. And there was kind of an argument that because there were several different executive orders that make up the mandate, that made up the city's COVID-19 vaccine mandates. And there was an argument that you were making, that Chad LaVeglia was making, that they were kind of all of a piece in creating this this mandate for everyone employed in the city, and then there were exceptions made to that, specialized exceptions for certain people.
I mean, I think that the mayor's office and the health commissioner together issued like 100 emergency orders relating to COVID vaccines, each one kind of adding or taking people away, or but they've been very clear when talking about it that it's all kind of one mandate, and each mandate references all the other ones in the clause justifying that one. So they really are all interconnected, and I think it's a cop-out for the city to now try to act like they're completely separate and they don't impact anyone else. I mean, that would be like saying, if everyone who made $300,000 was subject to a different mandate than everyone who doesn't make $300,000 a year, you're not impacted if you don't make $300,000 a year by the other mandate and the special provisions that they are getting. They're the same group of people. It's the same reasoning behind all the mandates. They're just different strokes for different folks, right?
Mm-hmm, mm-hmm. The city is also trying to argue that this case, that the original case was not filed in a timely enough manner. Can you talk about what that issue is?
Well, there are 4 claims in this case. So 3 of them, there's no question, they have years to file. But one of the claims has a very short, what's called statute of limitation. It has to be filed within 4 months of the final, final decision, which has been defined as a decision where there's no way to ameliorate it, and there's no way to appeal it further, and that's the date that a decision becomes final. So they're arguing that would be in February of 2022, so this would have been filed a few weeks too late. But really, our position is that since the Department of Sanitation told all of the workers and had in writing that they had until June 30th to comply with the health commissioner's orders, that it didn't really matter if they were notified in February. Their terminations really became final and binding on June 30th, when the health commissioner hadn't revoked their vaccine mandate, but had for all these other employees that are, higher status in the city's view.
And where does this case fit in the landscape of all the different cases that are in court right now concerning the mandates? Because it is a fairly major case. It's cited in a lot of other cases, including other cases that you're working on, yeah. I think. And there are hundreds of both individual and group cases still in court right now in both state and federal court. So where does Garvey fit into all of that? What's its significance?
Well, Garvey is attacking the validity of the mandate itself, which is a little bit different than a lot of the other cases, which are attacking the exemption processes and the discrimination that took place in implementing the mandates within each of these agencies. So even if Garvey were overturned, the religious discrimination and medical discrimination cases would still be separate causes of action. But Garvey is very important because, unlike those other cases, it doesn't depend on whether you had a religious or medical exemption request. It really just questions the validity of this mandate itself and challenges a very important question, which is whether the city can make one rule for rich people and one rule for the essential workers of the city. And,
Do you, there are some other major cases that you're working on. Do you want to comment on where those stand right now?
Well, sure. There are 2 major lawsuits that are currently pending a decision by the Second Circuit Court of Appeals in the federal courts. That is the New Yorkers for Religious Liberty and Kane v. de Blasio, and that's joined with another case called Kyle v. City of New York. But these are cases, one set of the cases are for teachers who worked for the DOE or people who worked for the DOE who were terminated, and one is for all New Yorkers impacted by these mandates. And we argued that case on February 8th, 2023, so we are still waiting on a decision there. And that case would have huge significance as well for all city workers. And some of the same arguments apply there, but just in a slightly different way. For example, the private sector employees are included in that lawsuit. And here they're arguing, well, this carve-out doesn't impact people who work for the city. Well, they won't have that same argument for private sector employees who were fired because of the mandate. Well, professional athletes and their entourages got a pass.
And what about the DiCapo case? That's another major case that's in state court.
So that was a case for the teachers, and we won a ruling by Judge Porzio in Staten Island that these 10 teachers were fired unjustly and unlawfully, and they should be reinstated with back pay. And the city appealed it. So we're going to go through this same process with that case.
And that is something that maybe will go to appeals in the fall? Because it's a complicated case, right? Because I know that there's an appeal and a cross appeal because it was kind of a mixed decision.
Right. Yes, it's going to go to, we don't know when it'll go to appeal. I mean, we briefed this one more than 6 months ago, I think. Maybe it was October. It was finished with all the briefing, and so we're going to have a similar timeline on DiCapo. But in the meantime, I do have two other cases that I'm bringing for teachers. One for teachers that went through the citywide panel and were denied by the citywide panel, which is everyone save one person, as far as I understand. The information we have so far is that the citywide panel only ever accepted one of the DOE employees in the entire 500 or so that they reviewed. So if you fit into that category, if you applied for a religious exemption and went before the citywide panel or had a denial by them, then you might qualify, so you can call my office because I'm going to be filing that soon. And the other case is for teachers who didn't go before the citywide panel, who were denied even that protection, even though the Second Circuit has already held that the original religious exemption policy was unconstitutional on its face.
So you're talking about new cases that are about to be filed?
Yes.
Yeah. Garvey, when I think you were saying earlier, it could be even a couple years before we see a decision resulting from the oral arguments that were made today in this case, because this particular appellate court, the second department, just has a lot of cases backed up. Yeah. So that is the timeline you're saying?
We have no way of knowing.
Yeah.
But they say that on their website, or they did recently anyway. I know that the second department has been working on it to try to speed things up. So I don't know. It's possible that they'll find a solution to the backlog, but
okay.
The crystal ball.
Well, thank you for talking with me. I see that there are a lot of city workers who came out to this hearing today, even though it's on a Monday morning. And
2.5 years later, people are still showing up. I think that's really the takeaway: is we can't let this go away. We have to keep up with the lawsuits. We have to keep showing up and keep showing them that we're not going anywhere, and we are going to, endure this process so that we can protect people in the future from this ever happening again. So, if people can the next time, there's a lot of people who showed up today, and I'm so grateful for that. So if you can come on out and show up when the court cases happen, if you can donate to Children's Health Defense or other groups that are really trying to help keep these lawsuits going, there's a lot of ways to get involved, whether or not you're a plaintiff.
Just to be clear, because Children's Health Defense is supporting this case.
They are. They made this appeal possible. Yeah. So they've been supporting it. They've been not like our full fee, but they've been giving Chad and I a little bit of money so that we can put the time into this. They've paid the filing fees, the costs of the record, and they've also been mooting with us and reviewing briefs with us, and very, very integrated into the process.
All right. Well, thank you for talking with me.
Thank you.